All right, guys, today we're going to talk about mandatory arbitration and class action waivers. So in previous videos, we have discussed the importance of preserving your rights and also some strategies that defendants use in order to attack consumer cases, which otherwise are very straightforward violations of the law. Okay, and just kind of recapping some of that stuff, we have a video that discusses how defendants will attempt to defeat cases by saying no damages exist and therefore there's no jurisdiction of the courts to hear it. This issue of arbitration also deals with jurisdiction. Okay, so typically what will happen is somebody will suffer a violation of the law and they will attempt to enforce their rights in state court or federal court, right? And time again, when you're dealing with the first party, the party with whom you actually had the contract, they will invoke arbitration. Now, first of all, we've kind of got to do a little bit of background when we're talking about who might be able to do this. So typically you don't have, what arbitration requires is arbitration requires an agreement to exist with somebody. So you have an agreement with your credit card company. They'll loan you money and you agree to repay that money under certain terms, right? You have a deal, an agreement with your bank. They hold your funds in trust and custody and care, and in exchange you agree to not overdraw your bank account, right? You also have an agreement with certain service providers. So people who might have provided a particular service for you, such as the pest control company, or potentially like a roofer, or a repair person of some type. These people could end up posting on a credit report if those obligations were not fulfilled. But the point being, you have an agreement with that individual or that company or whatever the situation is. You're actually bargaining with that person. Okay, so people with whom somebody bargains can, in theory, agree to arbitration. So you can agree between two parties to say, hey, look, we're not going to utilize the court system. Instead, we're going to use this vehicle called arbitration, which allows us to, in theory, resolve disputes between us in a fast and efficient manner. Okay? And rather than having to do a motion and a notice of motion and a motion itself and then a memorandum and schedule it out on certain deadlines, arbitration can, in theory at least, provide quick, easy things, right? It can, rather than a motion, it can be an email. We think our situation is like this, and the arbitrator may accept that email as just simple, a simple articulation of your particular problem, and the other side can submit an email, and it's faster, it's quicker, it's more efficient. And that's arbitration in its best form, where two equally situated parties agree to resolve their dispute in a more efficient manner. Nothing wrong with that, right? The problem that we see as consumer attorneys is when one side forces arbitration. So you have unequal bargaining power. Okay? They say, look, in order for you to open a bank account, you need to agree to arbitration. This is not an equal playing field because, for example, the prevalence of Wells Fargo, right? They're a competitive company and they drive other banks out of the particular neighborhood. You might not have a small bank next to you. Therefore, Wells Fargo might be that only option in banking available to you, and they force their consumers to agree to arbitration. Well, arbitration in this form isn't that fair bargain. It's not that agreement where both sides are equally situated. Instead, they say, hey, you agree to our arbitration agreement or the highway. Well, this starts to present some serious problems. This form of arbitration allows the company, the huge megacorp, to dictate the terms on how the dispute is to be resolved. Okay? So Megacorp can now say, look, all situations will be resolved, all disputes will be resolved pursuant to arbitration the rules under which will be modified with the following provisions, and you can only use the American Arbitration Association. Okay. You start to see how some problems might arise from this. One, they can write the rules to favor themselves. Two, you can have a situation where an arbitrator, even the best person, now has a financial incentive to find in favor of the company, should they ever want to be employed as an arbitrator again. And guess what? If Wells Fargo has said, we're going to use the American Arbitration Association, and there's only 10 or 15 arbitrators available in your area, and that arbitrator hands down a poor decision to Wells Fargo, well, Wells Fargo in the future isn't going to allow that arbitrator to be selected. Now, you see very quickly that arbitrator who's not engaging in the game, in game theory, this is called a repeat game. If it was a one period game, then the arbitrator might do the right thing, right? But when the arbitrator is engaged in a repeat game, now the arbitrator actually has a financial incentive in the future to find in favor of Wells Fargo. This is as close to possible as an outright bribe. There is a financial incentive to find in favor of Megacorp. Okay? I will call it what it is. It is a bribe. Okay? The Supreme Court has said this is perfectly okay. Through a series of actions beginning kind of in the mid-'80s, but prior to the mid-'80s, the Federal Arbitration Act was established in the early 20th century. And specifically what the Federal Arbitration Act says is that two parties can agree in a contract to resolve their disputes via arbitration. Well, state legislatures, being smart individuals, quickly realized, well, this might not be the best for employees or for consumers, and therefore they limited the ability of employers to force people into arbitration. They limited the ability of certain banks and collection companies and, I should say banks and other lenders, payday lenders, etc., to force people into arbitration via state laws. But through an expansion of federal law, starting in the early 80s roughly, we saw business interests together with the American Bar Association. I will call out the lawyers for what they did. As a lawyer, I will call them out. The American Bar Association in assisting these corporations to start removing the right for people to go to court. More and more of this happened. And the Supreme Court, over a series, there were nearly 24 cases, I believe. I won't give you the exact time, but at any rate, they continued to erode consumers' ability to go to court to our modern incarnation of what we've got today, which is basically says, look, if there's an arbitration agreement, not only are you forced into arbitration pursuant to the terms of that agreement, but guess what? Whether or not the agreement applies is also an issue for the arbitrator to decide. So we can't even make a preliminary decision, should this arbitration clause apply or not, in federal court or state court, in court generally. That is all up to the arbitrator. So basically, if you agree to arbitration, you are playing by the company's rules. You are subject to limitations that the company establishes in their contracts, and we'll go into some of the issues. But I want to give an example from a recent case. Okay, we had a recent case. I had a client who suffered a sexual assault, and that sexual assault took place by an employee of a company called Public Storage. And Public Storage puts in their arbitration, or at least did at the time that this case arose, put into their arbitration provision a limitation on damages. So they said, as you know, one of the issues or one of the things that you agree to in entering into this contract is that in exchange for using this service, I believe it was $5,000. Your damages of any tort whatsoever were limited to $5,000. Okay. We brought the case saying that's unconscionable. That's crazy. You can't do that. You can't limit somebody's damage. And they also, I believe, had a shorter statute of limitations. So you needed to bring a case within a year. So the maximum damages you could get. So you could picture the situation where, an employee is drunk and drives their car into a family minivan, which explodes into flames. And according to Public Storage, that case would need to be arbitrated and could not be, would be the maximum damages that could be awarded under that would be $5,000. That's insane. But we bring this court in Minnesota, this case in Minnesota State Court, and the court finds that arbitration provision is not unconscionable, and my client is forced to go to arbitrate their claim. That's how serious this can be. That is how serious this can be. She suffered a sexual assault by an employee of Public Storage. The lawyer for Public Storage, I'll call them out by name if I'll look that up. I'll post it in the comments because they make the case and they say it right in arbitration. No, her damages, despite a sexual assault, despite us saying this may have happened, the individual argues, the lawyer argues, nope, it's limited to $5,000. So that is the seriousness of again what we are dealing with forced arbitration. But it gets better. Okay, it gets even better than this, and I say that in the most sarcastic way because not only has the Supreme Court held that arbitration applies even in unequal bargaining positions, such as a consumer bargaining against a bank or a credit card company, a desperate individual looking for funding. Not only does arbitration apply, but class action waivers also apply. So, in that same bargain, what the Supreme Court has said in the case, it was AT&T versus Concepcion. Actually, I have it here. So, what the Supreme Court said in that case is that the company can also insert into their agreement something called a class action waiver that says you're waiving your rights as a prerequisite to doing business with us. Excuse me. As a prerequisite to doing business, whether a condition of doing business with us, you are also waiving your right to bring a class action, to be a member of a class. So that means anybody who's I believe American Express has a class action waiver in their contracts. Anybody who is a American Express card holder cannot be a member of a class action against American Express. So American Express, in theory, could steal 5 cents from you, 5 cents from every single person, and guess what? Nobody's going to bring that case. Nobody's going to bring that case. Are you going to spend $20,000 in attorney's fees to recover 5 cents? No. This gives them a free pass. Lest anybody think that American law is somehow an even playing field and you can get your day in court, have that notion deleted from your mind right now. American law does not provide you that right. It does not provide you the right to a jury trial. And this has been a systematic attack on consumer rights by businesses and, quite frankly, assisted by the American Bar Association. It's been an attack on consumer rights in this country and people's ability to resolve their disputes in a court of law, something our founding fathers, this is the 3 legs of the governmental stool, right? I mean, so you've got the judiciary, right? You've got the legislature, and you've got the executive branch. And the judiciary is, we can't emphasize the importance of this very American concept of everybody's entitlement to their day in court. And that simply does not exist in the civil context and simply does not exist in the consumer context as of today. And quite frankly, I do not see a way of relief if American Express decides to start stealing 5 cents from you. There was this campaign, attack against lawyers. You know, I've ripped on lawyers now because, quite frankly, they did the damage of this. But I'll now tout the importance of class action lawyers and what they did for this country in terms of creating product safety, right? So that we don't have children killed by dangerous devices, so that we can generally function with some degree of certainty that we're going to be safe in our vehicles and safe in our homes. A lot of that was due to tort lawyers bringing cases and bringing product liability cases. Class actions lawyers were very, very important to making sure that big corps didn't steal 5 cents from people. And there was this idea, well, these lawyers, they get all the money from this class action. Well, quite frankly, I would gladly give my 5 cents to the lawyer who's assuring that they don't steal 5 cents from me next time, right? If that lawyer is going to enforce the law against American Express, making sure that American Express doesn't steal 5 cents from me. I don't see a problem in that. If there is an enterprising individual who wants to go out and find that case and litigate that case, yes, I benefit from that. I absolutely benefit from that, and they can gladly take my 5 cents. That is not the case anymore. But all is not lost. One important point to emphasize with both the class action waiver and arbitration is that it requires an agreement to be in place, okay? So, although we have no rights against our collection, or our credit card company or our bank, and quite frankly, I call arbitration no rights because in my experience in arbitrating, you typically have retired judges, you have retired lawyers some of the time, you have otherwise, individuals who have represented companies for years working as arbitrators. There's not a huge, deep bench of consumer lawyers available out there. So, the vast majority is people that are, I would argue, adverse to consumers in many ways. And quite frankly, when a judge retires from the bench, they're typically older, right? They're older, and they're maybe not as sharp as they were at one point. So you have arbitrators who, quite frankly, a lot of the time are off in left field. These guys are not, my experience has been, there are not a ton of sharp cookies serving as arbitrators these days. It's very rare to find the attorney who's like, what I want to do is I want to, really be the arbiter of these fairly petty consumer disputes, and that's why I went to law school. And rather than actually being a judge, I want to do this. Not very common. Okay, and you can imagine the weird duck that would like to do this. So these arbitrators are typically not, I've found, have not been particularly impressive. I found a lot of them to be really off in left field. I've seen senile arbitrators, I'll say that straight up. I have seen arbitrators who have no command of the underlying law, who have made massive mistakes, and quite frankly, the credentials necessary to be an arbitrator are basically non-existent. You need a one-day class which you can largely sleep through, which has no exam at the end of it. And quite frankly, I'm a registered neutral, and I can't remember if I have the arbitration. That's literally where we're at. I literally can't remember because I think I was writing a memo while sitting in this class. I just said that on camera because I think this is a joke, and I took it because I think it's a joke, and that only confirmed it is that big of a joke. And the next thing I know, they gave me a certification. It's a joke. It's literally a joke. This is a massive problem for the American consumer. There are papers upon papers written about it, but it is a somewhat esoteric area of law in that Joe Schmo is not going to understand how bad this is until Joe Schmo actually has something happen to them. At that point, they'll realize how bad it is. But it's hard to get crowds riled up to say, hey, look, Congress, you need to change the American Arbitration Act because we really care about this. And by the way, you need to also get rid of class action waivers because it turns out all that crap we read from these businesses lobbying the American consumer with the belief that they're so stupid that they'll vote against their own interests, unfortunately was accurate. It's terribly unfortunate, but they managed to convince people that businesses should be able to steal 5 cents from people. That's perfectly okay. And people bought it. They bought it. They totally bought it. You know, this goes back to the McDonald's coffee, and I believe a firm called Williams and Connolly were involved in kind of selling this McDonald's coffee deal that, this individual, spilled a cup of coffee in her lap and got, $4 million or whatever the figure was. In reality, the flesh fell off of her leg. When you look at the pictures from it, I encourage you to go Google that. But the sales pitch to Joe Schmo out on the street is that, hey, somebody spilled a cup of coffee in their lap and they got $4 million, and this is the problem, and this is why you should not buck when American businesses try to do away with tort actions through tort reform, is the way they branded this. It was largely conservative parties which supported this. I think it's a fundamentally, I think it's fundamentally against conservative values to say that you don't get your day in court. But unfortunately, the Republican Party in particular really just eroded this area of consumer rights in favor of big business, and this is where we're left. Again, though, I will go back to the fact that not is all lost. All is not lost. The fact of the matter here is that arbitration does require an agreement to be in place. So, who can you actually still sue? Well, this series is about the Fair Credit Reporting Act. So you can sue CRAs, right? You don't have an agreement with Equifax. In fact, if Equifax, asked me, I would probably say delete my credit file. Don't do it. I don't want one. But I can't do that. They collect information whether or not I like it. They're going to continue to do that, and I don't have any agreement with them. Now, you do have to be careful because if you bought a credit, report through Equifax, they probably sneak it down into the text. That is my guess, that they say, hey, look, if you've got an issue, you'll have to arbitrate this. And this, actually, I litigated a case. I got one of the first jury verdicts against Equifax for the 2017 data breach, okay? And I found in the terms for the free credit repair that they were offering, they buried an arbitration clause in there. So every single person that was signing up for their free credit monitoring, repair, whatever the hell it was, program, was also agreeing to arbitration. That's how sneaky this stuff is. And it was not on the first screen. It was buried in the text. But as soon as you click that yes, sign up for it, there you go. You're bound into arbitration, and now you can't sue Equifax, right? Now, they later pulled that out when called out on it. Anyway, so you can sue the CRA, okay? And who else can we sue? We can certainly sue a party if identity theft occurred, right? So if identity theft occurred, you don't have an agreement with that furnisher of data. So some furnishers, right? Okay, but really, the vast majority of furnishers who you're going to have an agreement with, that's going to be the original creditor. The other large group of furnishers that, outside of identity theft that you're also going to be able to sue is debt collectors, right? Although debt collectors have tried to benefit from the underlying consumer contract, which does have arbitration, and to date they have not been particularly successful with that, but I'm sure that we will see a continued erosion of consumer rights to maybe even have the consumer contract, arbitration contract imputed to debt collectors so that they can try to force people into arbitration as well. They certainly made those arguments in court, and they will continue to make those arguments in court. So, why is arbitration terrible? Number one, it's typically accompanied with a class action waiver, preventing individuals from being part of the class action, and therefore preventing any type of remedy for essentially theft of small amounts of money. A second issue is that damages are almost universally lower in arbitration than they are in court. So the amount awarded at the end of the case is just substantially lower than you would ever see in court as an average. And then there's also just the chance of success. The chance of success is significantly diminished when in arbitration, and that's because of that repeat player game, whereas these arbitrators have a financial incentive to continue ruling in favor of the corporation so that they are selected in the future to be an arbitrator by that corporation. So let's kind of just talk about some of the statistics that we see around arbitration. The CFPB did a study, I believe they started it in 2012, I'd have to look it up, but they said 53% of credit card agreements have arbitration provisions in them. 92% of prepaid credit card agreements have arbitration provisions in them. So you quickly see a little trend developing here. I'm going to skip down to here. It's 86% of student loans there, but I want to emphasize this one. 99% of payday loans have an arbitration agreement in them. This is interesting. 53% of credit cards, 92% of prepaid credit cards, 99% of payday loans. What's happening there? The poorer you get, the higher chance that you will be in arbitration. The poorer you get, the higher the chance you will be in arbitration. Down to payday loans where you are pretty much guaranteed to be in arbitration. Okay? This is a systematic attack on poor Americans, perpetrated by big business. It is a systematic attack on poor Americans assisted by the American Bar Association. And it's a travesty of justice. Whereas, essentially the poorer you get, the less chance you have of having a day in court. So this is something that is a serious concern. It's certainly an issue from an economic perspective, but I just cannot emphasize the poorer you get, the higher your chance of being here with a crazy old arbitrator who, quite frankly, passed out during their little arbitration class there, and the next thing you know, they're the person judging your rather complex statutory claim brought under federal law. That's the person you have doing it. I have litigated, I'm going to say hundreds of arbitrations. I think that's an accurate statement. I think it is in the hundreds. And what I've seen in arbitration is just a consistently lower product. It is a consistent misunderstanding of consumer law. It is a consistent misunderstanding of the law generally. It is, quite frankly, an embarrassing process. It is. It's an embarrassment for American law. And it is overwhelmingly slanted in favor of business. I get routine settlement communications that say, hey, look, there's an arbitration clause in play here. Your damages are not going to be what they would be in federal court. That is hilarious. I mean, the lawyer, the representative for the business is literally saying, we know for a fact, the mere fact, we don't even know who the arbitrator is going to be, but we know because this is an arbitration, you're not going to get a quarter of what you would get in federal court. That is, and they just say it outright. I mean, that is a negotiation tool. It's an arbitration. You should lower your demand significantly. And guess what? I respond to incentives. They're right. The person's not crazy. The attorney on the other side. The attorney on the other side is articulating a very good argument and a very logical argument. We are not going to get what we would get in federal court. I should lower the demand, or I should talk to my client and explain that to my client and ask my client if I can lower the demand. They're right. So if you want less money, if you want your rights trampled by large corporations, keep on supporting arbitration, because that's where you'll get. But for the rest of us who would like, who believe in an American concept of some equality, who believe in a fair playing ground, who would actually like their rights under federal law protected, I would highly encourage you to lobby your representatives and attempt to at least voice your concern regarding arbitration, and also take advantage of the opportunity to deny arbitration. Many of these agreements do allow you to opt out of arbitration. Now, it is buried in the text, and no normal human being, we have kids, we have jobs, nobody can read through their credit card statements all day and figure out the exact set of steps necessary to opt out of arbitration. But hey, if you've got one credit card and it's got an arbitration, or you're considering another one and you've got that time to do it, please God, do it. Please God, do it and opt out of arbitration, because you might need your rights someday. That's arbitration in a nutshell. That's class action waivers in a nutshell. This has been highly opinionated, and that's exactly what it should be. Because if I would challenge anybody to come and debate me on one of these issues. Big business, leave your comments down there. Tell me I'm wrong, and I'll quickly correct you. I will bring statistics. I will show you. I will bring real world examples. Come tell me I'm wrong. But I don't think you're going to be able to. So that concludes our talk on arbitration. A little more riled up than usual, but it is a frustrating process, and stay true to your American values and say no to arbitration. Thanks.